Hey everyone, Dan McKenzie here with the McKenzie Law Firm. We are an estate planning, estate administration, and small business counsel law firm in the Denver, Colorado area. And thought I'd make a video about a question that we get a lot of from beneficiaries especially, which is when can the personal representative distribute the assets from the estate? And sometimes the expectations there are really off from what really needs to happen. And the issue is that a lot of people, I see this on the estate planning side especially, but also in the estate administration side, is people are forgetting about half of the estate administration process, and that half is the creditors, right? Everybody's very focused on family members getting what they're, entitled to receive, and, who's going to get the assets and all those kinds of things. But a big, important part of doing an estate administration is also identifying any money that was owed by the decedent, figuring out whether it's still due, negotiating it potentially, figuring out whether you have the amount of money necessary to pay those bills, and then if you don't, figuring out who's going to get what, and that can involve court processes and all kinds of things. But it's really an important part of the process. It's just as important actually as paying off the beneficiaries, because really we don't want to have a situation where months or even years after beneficiaries receive their assets that some creditor shows up and says, I wasn't correctly notified, I wasn't correctly given the amount of time that I was supposed to receive to make my claim in the estate before the family members ran off with the money. And so you need a little bit of patience. There's a process here. And so it does depend on how long it's been since the decedent passed away. Sometimes, I would assume, and it's certainly my experience, that most probate processes are opened relatively soon after a person passes away. Usually the family members do want to kind of get things figured out. If they have a house that they got to get sold, or a mortgage they got to get paid off, or there's bills coming in, they want answers to all that stuff, and that's a big part of opening a probate process. So usually people are pretty motivated to do that. But if it's been more than a year, the rules are a little bit different. On you don't have to pay quite as much effort into notifying creditors as you do if it's been less than a year in Colorado. And there's a couple different notification processes. There's because there's different types of creditors out there. There's creditors that you know about. So like if you're the personal representative, you might know, for example, that there's a mortgage on the house, right? That's a public record. And you might be receiving mortgage statements in the decedent's mail. And so that's a known creditor. There might be creditors that people are going to send a bill, they just haven't sent it yet. So if the decedent spent time in the hospital at the end of their life and you haven't received any bills yet, that those bills are going to be coming, and you can't necessarily avoid them by hiding from those creditors and not telling them where you are and those kinds of things. So known creditors, there's a couple different processes for notifying them. You do have to directly notify them. Again, this depends on how long it's been since the decedent passed away. And there are some pretty nuanced rules here. So if you're worried about creditor claims especially, I really would recommend speaking with a lawyer and making sure that you're doing that part correctly. Because like I said, it can come back to bite you if you haven't done that right. And then, as you can probably guess, the other type of creditor is unknown creditors. And you might assume that, if you're the personal representative especially, that you know who that person owed money, especially if you're a close family member. But the probate system does not make that assumption, right? So there could be people out there that, think they're owed money. They might even have a note or some sort of documentation that is not publicly recorded, that they have a contract or a note or something in their filing cabinet, or a letter even saying, yeah, I owe you that money and I'm going to get it to you. And if the personal representative doesn't know about that, how do we make sure that those people have had a fair chance to get their claims addressed? And so for that, to make sure that that is not an issue, the personal representative runs a newspaper ad. And you might have seen these. Obviously the amount of newspapers out there these days and the amount of people reading newspapers is less and less every day. And so I don't know, what's going to become of this process as that kind of trend continues. But for the moment, you do have to run a newspaper ad. 3 times over 3 weeks in the county where the person who passed away was residing, and just announced that, hey, this person passed away, there's a probate process open, here's the case number, here's the court where it's at, here's the identity of the personal representative. If you think they owed you money, let that personal representative know, and you have 4 months to do it. And if the personal representative gets any claims, it is part of their job to kind of determine whether they are valid claims, again, and whether they need to be paid and whether there's money to pay them and all that kind of stuff. Again, very different rules on this depending on how long it's been since the decedent passed away. So, and sometimes there's a little bit of strategizing involved with this, because sometimes people will actually wait, to do this and not do it, because after that year has passed, you don't necessarily need to notify certain creditors. So sometimes people, if they're really concerned that there might be creditors, more creditors out there than the estate can handle, or that there's creditors that have very large, the estate might have large obligations to, there are ways to kind of strategize out and wait for that year to pass before you actually make distributions. And so again, don't just assume that you have to run the newspaper ad, or that you should, but also then on the other side, you got to be very careful about actually making distributions too soon. We've seen that happen too. I have a client who opened a probate process and actually recorded a deed the same day, transferring a house out of that estate. And obviously, no creditors were notified before that happened. And again, that doesn't mean that they don't have a claim. Now it's just like the personal representative can be personally on the hook if they didn't, if they can't get that asset back, and if they can't make creditor payments that were valid and should have been done. So personal representative, this is a real minefield for them. Getting back to the original question that I addressed at the beginning of this video is, when can you expect your payment? Well, it really depends on how confident the personal representative is about how much money they have in the estate and how many creditor claims are coming. If they're fairly sure that they've got their arms around that and there's going to be plenty of funds, they can make partial distributions, but they really have to be careful. An estate that, like I said, there's 4-month time for creditors to make claims. A probate process is supposed to be open a minimum of 6 months. Creditor claims that might not have been validly notified, creditor claims get extinguished after a year, even if they're not necessarily notified correctly in some circumstances. So there are reasons that the personal representative needs to wait, and that might be more than a year. Especially, one of the biggest most common creditor claims, of course, is the IRS, right? They got a tax bill due. So if you're the personal representative, you got to be very careful about this. And if you're a beneficiary, you just got to be a little bit cognizant of the fact that there is this duty of the personal representative to identify creditor claims and correctly take care of them. And they can't necessarily just shoot money out without being sure about that. And that can really take some time because of these processes and the amount of time that creditors are given to actually make their claims. So every once in a while we hear beneficiaries say, hey, it's been a month since Dad died, where's my payment? And it's like, it might be a lot longer than that. And it might be very reasonable that it's going to be a lot longer than that. So if you have questions about this, like I say, this is a real minefield for personal representatives. It is probably the part that they need to be the most worried about the whole thing. I mean, obviously, sending money out in incorrect amounts to anybody is never great, but you really don't want to be a personal representative in a situation where you've got a creditor showing up after you've distributed assets and find out that you don't have enough money to pay a valid claim. So that's their big fear. And so you got to be careful there. So in that circumstance, again, even with lawyers, there's a lot of double checking deadlines, and just making sure that everything's handled, every I is dotted and T is crossed, and that's done correctly. So again, if we can be helpful on that, we're happy to talk with people who are dealing with this in Colorado. Again, our name is the McKenzie Law Firm. Our phone number is 303-578-2745, and hopefully this video is helpful for helping people set expectations about why certain distributions might be taking longer than they expected, or the estate might be taking longer to administer than they thought it would. Thank you, and hope this was helpful.